restrict or prohibit in any way the sharing or sending or receiving of information with naturalization or the Immigration Naturalization Services on immigration status, whether that is lawful or unlawful.
Real quick before you go on, do you know if either of those statutes have been challenged in court?
The two federal statutes? I do not know if they have ever been challenged. I know that they remain on the books as existing federal law.
Okay, thank you.
I'm also going to not make any value judgments, so we're going to have a local focus here. And by local focus, I mean I'm going to focus on the aspects of SB 54 as they will relate to Hemet and Hemet's police department and their operations. There are aspects of SB 54 that, for example, impose requirements on the California Department of Corrections, or that impose obligations on the California Attorney General. The AG is responsible for putting together some model guidelines to issue to subdivisions of the state of California, like schools and courthouses, that discuss limitation of their cooperation with immigration enforcement agencies. I'm not going to go through those in detail, but they are part of the law. They don't directly impact the city of Hemet. One of the things I think is very important to understand SB 54 is to put it in its full legal context. And this might take me a few minutes, and hopefully I don't talk so long tonight that you and the audience go numb and forget why you're here to comment, but I'll try to move along and be pithy, but this is a complex law. So SB 54 builds upon a couple different laws that were enacted a couple years ago. The first is the Trust Act, full name of which is the Transparency and Responsibility Using State Tools Act. The other one is the Truth Act, the Transparent Review of Unjust Transfers and Holds Act. And then finally, SB 54's name actually is the California Values Act. Now, all of those occurred from 2014 to 2018, but they built on quite a long history of debate about whether or the extent to which local and state law enforcement agencies should be involved in federal immigration law. One of the major turns of this took place in 1996. Well, before the Trump administration or the Obama administration or anything else, in 1996, the Immigration and Nationality Act, which goes back to 1952, has been amended several times, was significantly amended in 1996, and it added a particular subdivision to Section 287 of the Act that allowed the Immigration and Naturalization Services, now performed by ICE, to delegate immigration responsibilities to states and local jurisdictions under a memorandum of agreement with what's now ICE. And under such memorandums of agreement, local law enforcement authorities could utilize the administrative powers of the federal government to do warrantless arrests, stops, detentions, and searches to a certain extent, using entry into the country as the premise for that. That created a decade-long debate about whether that was appropriate, whether that created lack of trust in part of the local community, whether that led to people not being good witnesses or not talking with police. I don't intend to get in and take a side of that, but that is the debate that has gone on. And that specific power that ICE still has be able to delegate things through a memorandum of agreement to local jurisdictions that ultimately culminated in these acts: Trust Act, Truth Act, and Values Act. Not to mention the political background with regard to what the immigration policy should be and the different policies that states took with regard to that. A couple of other things. When I mention local law enforcement in anywhere in my presentation, I'm talking about local police departments and the sheriffs. If I mention immigration authorities or immigration agencies, that is only to federal agencies. And generally, they're the three major agencies that deal with immigration under the Homeland Security or Department of Homeland Security. That would be the U.S. Customs and Border Protection Services, U.S. Immigration and Customs Enforcement, ICE, and USCIS, U.S. Citizenship and Immigration Services. Now, it's typically Border Patrol or ICE that would be on the enforcement end. USCIS is really the one that processes the applications for citizenship and entry. Let me note here two things that will become necessary to understand later on. Immigration law can be enforced both civilly and criminally. And so through this law, you'll see where it refers to being involved in a civil enforcement of immigration or criminal enforcement of immigration. Civil enforcement of immigration is generally what we all think about finding people who have crossed over the border illegally, who are in the country illegally, arresting them, detaining them, and then deporting them. That's a civil procedure. While entry into the country is criminal in nature, generally it's handled in a civil manner, which means the arrest warrants don't have to be issued by a judge. They can be issued on reasonable suspicion as opposed to probable cause. There's authority for the state agencies to detain the individuals until they go before a judicial hearing that determines whether they're eligible to remain or they can be deported. That's the civil procedure. So when we say civil immigration enforcement, that's what we mean. Civil immigration enforcement was one of the things that you can be delegated authority for under those memorandums of agreement with ICE that I mentioned under 287G of the Immigration and Nationality Act. Criminal immigration enforcement generally has with somebody who has been barred from entering the country, has been deported once, and is now re-entering criminally, or has committed some type of crime while in the United States and was deported because of that crime. Any re-entry by that person or crime involved by that person can be criminal enforcement. That'll become important later on. So let me go back and take you through just a snapshot of what the Trust Act, Truth Act, and Values Act are. So the Truth Act established the circumstances under which a local law enforcement agency might detain an individual past their scheduled release in response to a hold request by ICE. Local law enforcement arrests somebody. They're in jail pending arraignment on their local criminal charges. They come up for arraignment, they're going to be released, and ICE would issue the jailer a hold request. Hey, hold this person while we get our transfer request processed and delivered to you. That's kind of what a hold request is. I want to note at this point, though, that those hold requests come to the people who are responsible for the custody of those criminals, the people who have been arrested, the detainees. And that's typically not the Hemet Police Department. It's usually the county sheriff because they go to the county jail or the detention facility. It's not operated by Hemet. So most of the hold requests don't go to Hemet. They go out to the detention facility. So next, the Truth Act. The Truth Act created a mandatory notice and procedural protections that local law enforcement agencies had to comply with before permitting ICE to interview a person in their custody. So if you had somebody in custody awaiting arraignment or something because they were arrested for a local crime and ICE wanted to come in and interview them, the law now requires that jailer, the handler, provide certain notice to that detainee and go through certain procedures. By and large, again, that's something that Hemet PD is not going to be involved in because anybody we arrest isn't going to be sitting for a long time in the few cells that are here. They're going to be going down to the county. And so finally, what is the Values Act? California Values Act prohibits law enforcement agencies from undertaking federal, civil, and criminal immigration enforcement, with certain exceptions, and it sets parameters on the local law enforcement's ability to engage and interact with ICE related to federal, civil, and criminal enforcement. So now I'm going to go through what SB 54 does in a little more detail for you. This is the basic prohibition. So it prohibits law enforcement agency from using resources, their money, their time, their personnel, their equipment, to investigate, interrogate, detain, detect, or arrest person for immigration purposes. It's important to note that under SB 54, people can have immigration violations. It's just that the primary reason for the local agency's action can't be to enforce immigration laws. Immigration enforcement basically means any efforts to assist a federal immigration authority with investigation or enforcement of immigration law. So there are some express prohibitions in SB 54. And I should say, if you have questions as I go along, please stop me down. It won't too disorient me. I'll be able to pick back up. So first, honor ICE hold requests. So whereas the previous act said they're going to put conditions on when you can honor an ICE hold request, under SB 54 now, you can't. No local law enforcement agency, city or county, can honor an ICE hold request. You cannot inquire into an individual's immigration status. This is one of the elements that has been pointed to as being potentially inconsistent with or preempted by federal law. The local agency cannot provide personnel information as defined in the California Civil Code to immigration authorities. I've put up the definition of personal information over on the other column so you can see basically what it is. It's very generic information for the most part. Name, I thought social security number was a little ironic, especially if it's a person who is actually an alien. Physical description, home address, telephone number, education, financial matters, medical history, employment history. And finally, it cannot make or intentionally participate in arrests based on civil immigration warrants. And so I described a little bit about civil immigration enforcement. Civil immigration warrants are not judicial warrants, like the search warrant that you would see that the police officers always have to go get before they go into somebody's house or inspect somebody. These are warrants that are administrative in nature, issued by ICE officers that simply identify an individual as being somebody they have a reasonable suspicion is in the country illegally, and they issue a warrant to another ICE employee to detain that person, arrest them, and then have them processed. So we're not supposed to, anymore, we're prohibited from taking any action with regard to those immigration warrants. also prohibits our local police officers from engaging in a number of what are called immigration-related activities. So local law enforcement may not perform the function of an immigration officer, assist immigration authorities with immigration enforcement at the U.S. border. They cannot be supervised or deputized by immigration authorities for immigration enforcement. They can't use immigration authorities as interpreters for persons in custody. Can't provide office space exclusively for ICE or California Border Patrol. That's Border Patrol at California border. And you can't contract with the federal government to house federal immigration detainees. So the city of Hemet was thinking about wanting to contract with the federal government to house federal immigration detainees. We can't do that. So one of the main things in SB 54 has to do with the limitations on holds, transfers, and notification requests. Holds, I've explained. Somebody's in custody and they're about to be released and you just want them to hold them over a little bit until the transfer request arrives. Can't do that. No exceptions under SB 54. SB 54 does place restrictions on honoring ICE transfer and notification requests. There are many exceptions which I'll go over, but I will note that the law also gives authority to local law enforcement agencies not to honor any of these transfer or notification requests, which is another item that has been identified as potentially being inconsistent with, contrary to, preempted from by federal law. Hold request, I think I've already described. If you have questions about that, I can address it. A transfer request is simply the next stage. They're asking to actually take custody of that person who's been detained for a local law enforcement related matter, and ICE is going to take custody, transfer them into their custody and facility for an immigration related matter. And so here are the exceptions that allow us to honor a transfer request. We can honor an ICE transfer request. And remember, this presumes that the City of Hemet Police Department actually is holding this person in custody. It's generally not all likely ever to be the case, because we're not going to hold them in our cell that long. They're going to be in the county, which means it's going to be the county who's going to be going through this, and this is going to impose on the sheriff and the jailers at the lockup facility. But ICE transfer requests can be honored if they're authorized by judicial warrant for a criminal violation of immigration law. They can be authorized if there's a probable cause determination by a judge for a violation of criminal immigration law. Now, probable cause determination in our judicial system usually happens at a preliminary hearing. So you get arrested, you get an arraignment, and then you come in for a preliminary hearing to see if the judge thinks that at least the crime that you've been arrested for and charged with meets a prima facie case. That's a little bit down the road in the criminal proceedings for the judge to then make that order. Or, and this is what I think is the largest exception, if the person who's detained has been previously convicted of, this is my own phrase, an egregious criminal conduct. I'll explain to you on the next slide what that means. It's a combination of several different specific felonies as described in the statute. But for right now, we can honor an ICE transfer request if somewhere in that detainee's criminal record was a conviction for egregious criminal conduct. Notification request. A notification request is really simply just ICE asking the local law enforcement agency, let us know when this person is going to be released from custody so we can pick them up. That's it. Just let us know when they're getting out. Under SB 54, local law enforcement may only do that if the information is publicly available. I think you've probably all read the stories about the Orange County Sheriff who was saying, we're just going to make it all public. We're just going to post all of them all the time. Well, that fits under that criteria. The other exception is if the person has been arrested, not convicted, but if the person has been arrested for egregious criminal conduct and there's been a probable cause determination of the commission of that crime. And remember I said over on the other side that that probable cause determination happens after arrest, after arraignment, at a preliminary hearing, so a little bit farther into the criminal process. So what is egregious criminal conduct? So we can honor ICE transfer requests if the individual has previously been convicted of a serious felony, a violent felony, a felony that are certain specified crimes, or what are called wobblers. Wobblers are those things that were created under Prop 47 where there's mandatory reductions of sentences and certain things that were a felony get cited as a misdemeanor and so forth. If you have a serious felony, then it can be at any point in time. Same thing with a violent felony. Certain specified crimes have to be within 15 years, wobblers within the past 5 years. And so what does it mean to have engaged in egregious criminal conduct? It means that you were convicted of committing the crime, attempting to commit the crime, conspiring to commit the crime, soliciting to commit the crime, or you committed some other crime with the intent of really doing the bad crime. I've listed them all. I'm not going to go through them. I've tried to group them together, but I mean they're the list of bad things: assault, battery, arson, murder, rape, use of illegal weapons, commission of a crime with a weapon, sexual abuse, sexual exploitation, anything that would cause the offender to be registered as a sex offender, bribery, extortion, obstruction of justice, escape, crime threatening public safety. Somewhere in here, I didn't think it put it down, but possession of weapons of mass destruction are included. Felony drug trafficking, felony DUI, vandalism with prior convictions, gang-related offenses, kidnapping, slavery, human trafficking, criminal profiteering, hate crime, stalking, and offenses committed while on bail. And being the subject of an outstanding federal felony warrant for any felony crime. Yes, sir.
You mentioned on the previous slide that these are exceptions where people were arrested, and then I think as you were describing the egregious criminal conduct, you said convicted. So is it
correct?
Which is it?
We arrest somebody for some local offense, felony, misdemeanor, whatever. We have them in custody. We can honor an ICE transfer request if they were previously convicted of anything on this list.
Okay.
We can honor a notification request if what we've arrested them for has gone through arraignment and pretrial hearing, and the judge has determined that there's probable cause that they committed one of these egregious crimes, the thing we arrested them for. So if it's transfer, they have to have committed it before. If it's notification, they have to have been arrested for this, and either the release date's made public or there's a probable cause determination that they committed the crime that's up there.
Thanks.
Okay.
Real quick, Eric.
Yes, sir.
You had mentioned a time frame of 15 or 5 years.
Yes.
Is that 15 or 5 years from the date of the offense, the date of the conviction, or the date of release from prison or jail?
It is, I believe, the date of conviction. I tried to find whether it was the date that the conviction would come off the record, but that's not the case. It was from the date of conviction. All right, so SB 54, in addition to prohibiting local law enforcement from doing certain things, providing that law enforcement doesn't have to honor ICE transfer and notification requests if we don't want to. And by the way, we don't have such a policy here in the city. It gives law enforcement agencies some discretion to do some additional things. Law enforcement can investigate, detain, and enforce certain federal immigration crimes. Interestingly enough, even though it sounded like we couldn't be involved in any of that, but it's limited to where somebody is re-entering the country. That means they've come in illegally, they've been deported, but the reason for their deportation or removal was that they were convicted of an aggravated felony and that their suspected re-entry violation occurred during an unrelated enforcement activity. So if we arrest somebody for commission of a crime and we have a reasonable belief that they're in the country illegally and that they re-entered the country, and we find out that it was based on prior aggravated felony, then we're able to investigate and detain and enforce that criminal violation of immigration law, or the weird caveats. I don't know how often that would come up, but we have the discretion to do that. We can provide an individual's criminal history in response to a request for information from immigration authorities, and can give specifics about the person's criminal history. We can participate in joint law enforcement task forces. This is something HPD does frequently. A number of law enforcement agencies involve joint local, county, state, federal task force. The only prohibitions are the primary purpose of that task force cannot be to enforce immigration law. And the primary purpose has to be some other legitimate purpose. All of the ones we belong to are not for primary immigration purposes. We can ask for information necessary to certify potential victims of crime for human trafficking. One of the things that ICE is able to do are issue things called U visas for victims of violent crimes, or T visas for victims of human trafficking, so that they can be safe, stay in the country, and act as witnesses against the people that committed the crimes, either the violent felonies or the human trafficking. We can also provide ICE access to interview an individual in custody. We have to give certain notification and procedural safeguards that I've listed. A couple obligations imposed on law enforcement agencies. We have to report the activities of joint task forces with federal agencies to the state. We have to report on transfer and information requests we've received from ICE and what our responses have been. And we have to hold at least one public hearing in the year following any year in which the agency provided ICE with access to an individual in custody. I'm not sure if that will ever apply to us, but it is possible that it could. Otherwise, it's really just what we do on a task force or how we respond to a request for information. Yes?
So these three things on this page, these are new just because of SB 54?
Yes, correct. Rob Webb collaborated with me on the presentation, and the next couple slides are his. If you have any questions about these, I'm happy to pull Lieutenant Lindbrock out of his seat and bring him down, but otherwise I told him I would be happy to go through these for him quickly. So currently, Hemet Police Department policy falls within SB 54. We're not in violation of SB 54. We do not intervene or enforce federal immigration law. Hemet is not the custodian of arrested or detained persons. I think I've highlighted how that applies under the law. And HPD will work with victims and witnesses regardless of their immigration status. Hemet Police Department does participate in a number of task force operations that include U.S. Border Patrol, Immigrations and Customs Enforcement, Homeland Security investigation. We do have officers who are cross-sworn with federal credentials. However, none of our task force operations focus on immigration violations. Therefore, they're not prohibited by or interfered with by SB 54. And primary concern or the primary burden of SB 54 really falls on the county jail inmate release policies, not us. And I think, as Glenn would probably note, the resources and time of the Hemet PD are really focused more on the crimes that are being committed here in town and not what's happening at the border or who's coming over. Obviously, if there are illegal immigrants that are involved in crimes, they become the subject of a criminal investigation, detention, and arrest, just like anybody else would be. Finally, I'd like to close with just a few issues that I know have been of interest to the council. The first, and I hope you have this, Stephanie, my assistant who's sitting in the audience, prepared this nice chart. Hopefully you have it. It looks a little bit like that. And this summarizes the positions that have been taken by various cities and counties that we were able to locate, and kind of what they've done, whether they've supported joined as an amicus. One city, Santa Ana, has, I guess, taken a position siding with the state of California in the federal lawsuit. And then what other cities have done with regard to a resolution, a letter, or taking no position with regard to SB 54. And finally, I know you had questions about the federal lawsuit. The feds filed suit against the state of California on March 6th. The deadline, well, let me back up. So the way that lawsuit works is it's essentially what's called a writ. It's not like a jury trial where two attorneys argue back and forth. It's two attorneys arguing before a judge. It's called a bench trial. And these always start with what's called a motion for preliminary injunction. The federal government comes in and files a motion asking the court to enjoin, to block, to stop California from further enforcing SB 54 and the related laws that I've mentioned. The court has to have a hearing on that. Both sides, state of California and federal government, will turn in written briefs to support the court's decision and argument. So the first amicus curiae, friend of the court briefs that were being solicited were for that motion for preliminary injunction. The deadline for cities to join and become an amicus to support the federal government's motion for preliminary injunction ran April 6th. The deadline for cities to join the state of California in opposition to the motion for preliminary injunction runs, I think, in a few days. That won't be the end of this suit unless the court rules in favor of one side or the other, and the other side decides to drop the suit. What will likely happen is the court will either issue a preliminary injunction or not, and then the matter will proceed to trial. There'll be additional briefs that will go forward, and so there will be another opportunity to submit amicus curiae, friend of the court briefs, either in support of the federal government or in support of the state of California. My guess is that it won't stop there and that this will go to the Court of Appeal and beyond. So there will likely be multiple other opportunities for you to submit briefs to the court. It does not appear that the city of Hemet would be put to the expense of having to hire my firm or some other firm to draft its own friend of the court brief. There are a number of organizations who are submitting those that will allow you to just sign on and be listed as a supporting agency. So should going forward you give us direction to join, there will be, I think, ample opportunities to do that. My office will continue to monitor the suit so that you'll be aware of what happens in it and when those other opportunities or windows of time open up. The state of California has filed a motion to dismiss. So one of the preliminary jockeyings is, of course, the federal government files its motion for preliminary injunction, and the state of California files what's essentially called a demur, but in federal court it's called a motion to dismiss, meaning federal government, based on just what you've written, you can't maintain a suit against it. And so the court will consider both of those at the same time. And we'll be interested to see when and what the court decides that. But we'll be briefing you on it. That is the end of my presentation. I am happy to answer any questions that you have. If you have none at this time, I am going to vacate the podium and make way for your speakers.
I do have some, but counsel, do you have any questions for Eric?
Not directly for Eric, maybe for Lieutenant Brock.
Any others for Eric? Okay. You answered one of my questions. The hold requests that are sent to the jail, I just want to make this perfectly understood, is that these are people that have been arrested for other crimes.
Correct.
Okay.
Yes, these are not people who have been
That have just come across the border illegally.
Correct.
These are people that have been arrested for suspected of committing a crime.
Yes.
Okay, and then I do have a question for Acting Chief Brock, and the rest of you do too. Linda, Bonnie, do you have any questions? Good evening, sir.
Mr. Mayor, members of council, good evening.
Welcome. Russ, go ahead.
Lieutenant, my first question is, I understand there's different types of jails. They're classified based on how long they hold people in custody. What type of jail is Hemet?
So, it's a good question. Jails are generally categorized in 4 different classifications, 1, 2, 3, and 4. We are even below a category 1, which is considered a temporary holding facility. In our station, we are statutorily allowed to hold adults for up to 24 hours, and we can hold juveniles for up to 6 hours.
Okay, so we would not have an occasion to hold somebody even pre-arraignment?
No, sir.
So hypothetically, a person gets arrested for a criminal offense, they would stay here something less than 24 hours. Either they'd be taken to the court for arraignment or they'd be turned over to county sheriff.
Yes, sir. While I don't know the exact time, my best guess was our average stay here is probably around 4 hours before they're transported to county jail.
Okay. Well, that basically answers my other question, because I was going to ask what the likelihood or what the history is that we would have somebody in our custody, in our jail, post preliminary hearing. So that's not going to happen.
No, sir.
Okay. Thank you.
You're welcome.
Okay, my question is, prior to SB 54 being enacted and becoming law, what, if any, of the activities of Hemet Police Department were interrupted because of this law, meaning you had to change what you were doing and how you were doing business?
Prior to the SB 54 becoming enacted on January 1st, 2018, we did have minor impact, only in the way of the Truth Act, which was enacted January 1st, 2017, required us to prepare forms which we would present to a detainee should we receive a transfer request, hold request, or request to interview. So it took me about an hour to prepare those forms, just so we would have them on hand in case they were ever needed.
Okay, and then so the day-to-day police operations, patrol operations, investigations, that didn't get impacted on how the officers out on the street were doing their jobs?
There's no incident that I'm aware of that was impacted by either the Truth Act or the Values Act up to this time.
That's good to know. So we're still enforcing the law, we're still we're not a sanctuary city because we don't let people get away with crime, correct?
Yes, sir. It has no impact on our ability to enforce local or state law.
That's what I was trying to figure out how to come about and ask in regard to the sanctuary and the process and how it affected me, how it was affected by you.
Thank you. Do you have anything else you want to add?
No, one question that I thought might come up is whether we release information on arrestees. We do. We keep an arrest log in our front lobby, so that information, for as long as I know, we have released, which contains the location a person was arrested, date and time they were booked, their name, their date of birth, and some general information as far as gender, apparent race, height, weight, stuff like that. So even before this was an issue, it was information we already made available to the public at our front counter.
So we're basically doing the same thing that the Orange County Sheriff's doing?
Yes, sir.
Releasing the information by the people that we arrest?
Yes, sir.
Are these people we arrest that do not get booked into county?
Yes, so if you look at our arrest log, again, that's available to the public in the lobby, it will give a disposition of that person, whether they were transported to county jail or they released on citation.
Okay, thank you.
Thank you, sir. Okay, I know there's a lot of people that want to speak on this topic, this issue. In respect for everybody's time, I want to limit your comments to 2 minutes because there are a lot of speakers. Please, when you go up there, if you can let us know if you are a resident of the city of Hemet and if you are in favor of SB 54 or if you are opposed to SB 54. Everybody's clear on that? All right, very good. Sorry.
The first speaker will be Jean Roberts, and Jean will be followed by Angelina Bernauer.
Sarah? Why don't you call 3 or 4 of them and have them line up against the wall so that we don't have to wait between speakers?
So following Angelina will be Brock Despain, Teresa Stedman, and Michael Fremont.
Aiden.
My name's Jean Roberts, and I am a resident of Hemet. I am against SB 54. First of all, we need to see what crime really is. It is against our citizens who are legal. It is against our communities and our nation. A crime like 9/11 was against a city, state, and our country. It was a terrorist crime. What is terrorism? The unlawful use of violence and intimidation, especially against civilians, in the pursuit of political aims. A terrorist is the same definition. What is the definition of crime? An action or omission that constitutes an offense that may be prosecuted by the state and is punishable by law. Synonyms like this would be offense, unlawful act, illegal act, felony, misdemeanor, misdeed, law-breaking, delinquency, criminality, illegality, felony. SB 54 supports what I have just described. SB 54 does not want local money going to uphold the laws of the land and protecting legal citizenry. Crime is terrorism by all of the above definitions. Crime terrorizes communities with rape, illegal drugs, murder, theft, assault, entering our country illegally, prostitution, drug gang behavior, violation of our state, local, and federal laws as written today. To support SB 54 is to support terrorism, no matter what form terrorism takes. Funding to keep terrorism from our borders, as well as communities, is well worth the cost. How much is life worth? Priceless. All of our law enforcement entities should work together with one another, no matter what the cost is, to keep us in our communities safe, as well as our country. There is no price higher than to lose a life enforcing our laws or to be a victim of terrorist criminals. SB 54 should have been put on a ballot, but our current governor knew that it would not be passed under the current restrictions.
Gene,
Don't
thank you.
tie the hands of our law enforcement, be it FBI, ICE, ATF, or our local police. We need to band together to fight terrorism. My last and final comment is this. Do not support SB 54 because it doesn't support our communities or our lives for safety.
Thank you. We appreciate your comments.
Oh,
Thank you.
I have 1 minutes. Okay, sorry.
Thank you.
Thank you. Please do not, for the sake of our safety.
Yeah. When you're up there speaking, also keep an eye on the lights up there.
Hello, my
Good
name
evening.
is Angelina Reidenauer. I want to begin by telling you thank you, and I'm sorry. Thank you for hearing us tonight. Thank you for giving me the opportunity to speak. And I'm really sorry that you're in the position that you're in. It's literally a sign of the desperation of Californians that our government is attacking us. They're unleashing criminals on us. And I'm not a lawyer, and I'm not a cop. But it just isn't common sense to let criminals loose on your citizens. And, you know, you shouldn't have to be dealing with this. But this is what we've been reduced to. You are the last line between what the state is doing to us, and this is insanity. And we're having to come to you. You guys shouldn't even be dealing with this. But since we're here, and this is what it is, I come from Beaumont, which I'm very proud to say opted out. I've been a native Californian. I used to be proud to say I was a native Californian. Now we're the laughing stock of the nation because it just defies common sense, guys. It's just common sense. But one thing I've seen is that cities want to know, well, what is it, because you guys are charged with taking care of the city. How does this affect Hemet? Let me tell you how it affects it. 800,000 Californians are leaving. They're calling it the mass exodus. If they leave, your taxpayers leave, the city's going to go down anyways. The only way you have to stop it is to step up. The people are begging. And I know that I'll move because when the state looks you right in the face and says, we're going to unleash criminals on you, I have 3 kids. MS-13, all this is insanity. If I stay here with 3 kids knowing they're unleashing criminals, I'm like an accomplice. And so are you guys. So is everyone here. If we allow this to happen, it's on us if this happens. If something happened to my kid and I stay here, it's my fault. And I'm really, truly sorry that you guys are in this position. You know, I'm helping out a campaign. Gary Jean Dron, he's the retired chief police of Palm Springs. And this is insanity. He's totally against this.
Thank you, Angelina.
Well, thank you for allowing us to share our thoughts. I'm going to take a different approach, folks. I'm
What
going
was
to
your
talk
name, sir?
about health. I'm not talking about law.
What was your name, sir?
My name is Rock. I've been a resident for 21 years, and I'm against it.
Thank you.
Going back to the Civil War, more troops on both sides were killed by disease than by bullets of both sides. If you look in history in World War II, more American soldiers were killed by disease than the Kaiser's bullets. Why? Nothing was taking care of the feces that was going all over the place that they had no control over. Just down near Disneyland, they had a 2-mile stretch. The judge was wise enough to allow them to take it down. They, 2/3 of the way, they had over 20,000 tons of garbage, 2,000 tons of feces, and they weren't even through. Los Angeles, San Francisco are approaching epidemic stage of hepatitis C because of the feces all over. This affects all of us, guys, whichever side you're on. This is our health, our children, and our responsibility. And I hope you look to this for the responsibility. We have to love each other enough to say no for doing the right thing. Thank you.
Thank you, sir. Good evening.
My name is Teresa Stedman. I'm not a resident of the city of Hemet. I live in the county, but I've owned a business in the city of Hemet, and I currently work for CASA, which is in the city of Hemet. And I'm opposed to SB 54. I was concerned by the 2 questions that were asked by council members, in that you wanted to know what is the impact on the city of Hemet. Are we obeying the law? Are we going to have any problems? Did this impact